Welcome to this explainer. We have a seriously fascinating journey ahead of us today. We're going to unpack the profound evolution of South African law. We'll explore exactly how it transformed from this rigid weapon of systemic oppression into a really vibrant, living framework that's fully dedicated to human rights and justice.
So here's our roadmap. We'll cover why legal history matters, colonial roots and pluralism, apartheid law as power, the shift to constitutional supremacy, and finally, substantive equality in action. Let's get right into it.
Section 1. Why legal history matters. Because, well, to understand the present, we really have to start by looking backward. The crucial point here is that understanding the past is absolutely the only way to truly grasp why the law operates the way it does today. There are deep, deep historical reasons for the current legal context. For example, looking at history tells us exactly why South Africa no longer utilizes the death penalty. It brilliantly illustrates that the law isn't just some static, unmoving rulebook, right? It's a living social science. Whenever a society's values and needs fundamentally change, the legal system has to facilitate that adaptation. Plus, history is quite literally still alive in the courts today through common and customary law, inextricably linking South Africa to the legal systems of the broader global village.
Moving on to Section 2, colonial roots and pluralism. Let's see how the imposition of European laws disrupted and eventually blended with the indigenous African legal systems that were already in place.
Thinking about the timeline, we can chart the major shifts in power that completely defined South Africa's legal journey. It starts way back in 1652 with Dutch colonization, moves through English colonization in 1806, hits the really grim enforcement of apartheid in 1948, and finally reaches the incredible breakthrough of democratic elections and a supreme constitution in the mid-1990s.
Let's zoom in on the very beginning of that timeline. Long before 1652, African people inhabited this space and lived according to their own highly intricate indigenous legal systems. But when the Dutch arrived at the Cape, they completely dismissed the rights of the indigenous population. Falsely deeming them unable to comprehend the notion of ownership simply because they weren't Christian, the colonizers violently imposed their own legal framework, known as Roman Dutch law, right onto the African people. Now, that legal framework imposed by the colonizers acted almost like a massive funnel, relying heavily on ancient Roman law. You see, the Dutch received Roman law into Holland, where these brilliant 17th and 18th century jurists, like Hugo de Groot, fused it with early Dutch law. That resulting Roman Dutch law was then shipped all the way to the Cape, becoming the absolute bedrock of the Western component of South African law. But here's the thing, those original indigenous laws never disappeared. This led to a really fascinating legal pluralism, and the two systems are fundamentally different. Indigenous customary law is communal. It's based on living customs passed down through generations, primarily regulating relationships between individuals. Western European law, on the other hand, is highly individualistic, formalized, and specifically regulates relationships between individuals and the state. So you have these fundamentally different views of community and justice existing, and actually still existing today side by side.
Which brings us to Section 3, Apartheid, Law as Power. This is a severe historical low point starting in 1948, where the legal system was explicitly weaponized to oppress the majority of the population.
To truly understand how apartheid was legally possible, we have to grasp a concept called parliamentary sovereignty. Under this system, the government possessed absolute, unchecked power to enact any law it desired. And the courts, they were entirely forbidden from instructing Parliament to change these laws or declaring them invalid. So even if judges looked at apartheid legislation and knew for a fact it violated international human rights and natural law, they were entirely powerless to strike it down under the sovereignty doctrine.
Using this absolute unchecked power, the apartheid state functioned as a total political autocracy. Through horrific, systematic acts like the Group Areas Act and the Bantu Education Act, the law was aggressively used to force land dispossession, dictate exactly where race groups could live, and just completely strip away basic civil liberties, like dignity, privacy, and freedom of movement. Beyond that, the law was explicitly designed to destroy opportunities, restricting education to guarantee that Black South Africans were permanently prevented from accessing thriving professional careers. That takes us to Section 4, Shift to Constitutional Supremacy. Okay, let's dive into the massive turning point that resolved this severe legitimacy crisis, the abolition of apartheid and the birth of a supreme constitution.
This next concept is the absolute crux of our entire explainer. After decades of resistance and the release of Nelson Mandela in 1990, the nation made the absolutely critical transition from parliamentary sovereignty to constitutional supremacy. No longer did the government and parliament wield unchecked power. Instead, the Constitution became the ultimate authority. It binds all branches of government, meaning any law or conduct that isn't in line with the Constitution is automatically invalid and of no effect. Game changer.
This incredibly powerful 1998 ruling from the Constitutional Court really cements the rule of law in this new era. It basically ensures that the state can never again act arbitrarily or outside the bounds of constitutional authority. The state must respect the fundamental rights of individuals, and the law has to be clear and applied consistently to absolutely everyone.
And to further guarantee that no single entity could ever again amass the kind of autocratic power we saw during apartheid, the Constitution relies on the separation of powers. This is a brilliant device that divides government functions into three distinct branches: the legislative branch that makes the laws, the executive branch that enforces them, and the judicial branch that interprets them. By keeping these functions entirely separate, the branches are constantly keeping each other in check.
Section 5, Substantive Equality in Action. Finally, let's look at how the new constitutional framework actually applies the concept of equality in real-world scenarios to heal those deep divisions of the past. I want you to consider this question for a second. Is all discrimination unfair? You might instinctively assume the answer is always an absolute yes, but Section 9 of the South African Constitution introduces a highly nuanced, extremely powerful approach to this exact question.
The reality is, to achieve true justice, the law must sometimes treat people differently. Think about it. Formal equality simply affords everyone the exact same rights. Imagine a law saying all children have the right to attend a public school. Great, right? That's formal equality. However, it completely ignores the fact that a blind child might require special programs or a specialized school to actually get an equal education. That is where substantive equality comes in. It provides for special circumstances to attain a genuinely equal outcome, heavily considering the disadvantages of the past, present, and future. It acknowledges that to correct historical exclusion, like in the workplace, for example, the law has to proactively level the playing field.
The 1997 Hugo case brilliantly illustrates this nuance in action. So, in 1994, President Mandela granted a special pardon to female prisoners with children under the age of 12. Well, a male prisoner, Mr. Hugo, challenged this. He argued it discriminated against him based on his sex. Now, sex is an explicitly listed ground for discrimination in the Constitution, meaning the discrimination is automatically presumed unfair unless proven otherwise. But the Constitutional Court actually ruled the discrimination was fair. Why? They reasoned it was a special act of mercy that didn't permanently restrict Mr. Hugo's rights, and, practically speaking, releasing all male fathers would have been an administrative impossibility. So the context and the intent completely changed the outcome.
Conversely, let's look at the Larbi Odom case from 1998. Here, a provincial rule demanded that all permanent teachers had to be South African citizens. Non-citizens challenged this based on their citizenship, which, interestingly, is an unlisted ground in the Constitution. However, the court struck this down, ruling the discrimination was unfair. The reasoning was that discriminating against non-citizens is analogous to those listed grounds. Foreigners are already a highly vulnerable, marginalized group in society, and denying them professional opportunities based solely on citizenship severely impaired their basic human dignity. As we wrap up this explainer, I want to leave you with a provocative thought. We've traced an incredible journey today. How can the profound lessons of South Africa's legal rebirth, where an entire system was rewritten from an instrument of brutal oppression into a powerful shield of substantive equality, inspire the dismantling of unjust frameworks globally? What other systems in our world are just long overdue for this kind of transformative justice? Keep that in mind as you look at the structures of power all around you. Thanks for joining me, and keep questioning the world.